When high-ranking public servants hold multiple critical roles, should they receive additional compensation from each, or does that, cross the line into double dipping? Today, we unpack a really significant Supreme Court case that shines a spotlight on how top financial officials serving on a government-owned board were compensated. It sparked quite a debate. This deep dive will explore the delicate balance between public service, the prohibition on double compensation, and, well, how our highest court interprets the law. How does the law truly draw the line for public funds? Welcome to the deep dive, where we take your sources, distill the court insights, and make sure you're exceptionally well informed. For this particular deep dive, we're dissecting a fascinating Supreme Court ruling that captured the attention of many Filipinos, drawing directly from the detailed legal documents.
Exactly. In this case, it isn't just some dry legal footnote. It's really a window into this ongoing tension in public service. How do we ensure accountability and prevent misuse of funds while also, fairly compensating top talent who might hold multiple vital roles? The Supreme Court's distinctions here offer crucial insights into that delicate balance and establish important precedents for how government-owned or controlled corporations, GOCCs as they're called, operate.
Okay, let's unpack this then, set the scene a bit. Our mission today is to thoroughly understand the case of Amando M. Tetangco Jr. et al., petitioners versus Commission on Audit Respondents. The Supreme Court decided this one, GR known 244-8006 back on September 17, 2019. So who are the key players in this legal drama, and what exactly was the core dispute about?
Right. At the center are the petitioners. Armando N. Tetangco Jr., Armando L. Cerratos, and Juan de Zuniga Jr. Now, these individuals served as members of the board of directors of the Philippine International Convention Center, Inc., or PICCI. This was from January 2010 to February 2011. And here's the crucial part, the connection. They were also top officers of the Bangko Sentral ng Pilipinas, the BSP. Mr. Tetangco was actually the BSP governor at the time. PICCI itself was established by a presidential decree, PD 520, and the BSP was its sole stockholder. Its board structure specifically included BSP officials as ex officio members.
Hold on, ex officio members. Can you maybe clarify what that means for our listeners? Because that seems pretty central to the whole controversy here.
Absolutely, it's key. When someone is an ex officio member, it means they hold that board seat automatically simply because of their other public office. So in this instance, it was because of their roles at the BSP. They didn't need a separate appointment to the PICCI board. And this is crucial because it raises that fundamental question. Was their service on the PICCI board truly extra work deserving separate pay? Or was it just part of their main job at BSP?
Right, I see. And what specifically sparked the controversy regarding their compensation from PICCI then?
Well, the issue arose from the per diems, the representation and transportation allowance, RA as it's known, and some other bonuses these officials received from PICCI. Over a few years, various monetary board resolutions kept increasing these allowances. Per diems went from around P6,000 up to P9,500, and they authorized a P10,000 RA. The total amount involved that was ultimately questioned by the Commission on Audit, or COA, was over P600,000, P618,500 to be exact.
Okay, so COA flags these payments. What was their reasoning? Why did they see this as problematic?
So on post-audit, COA's audit team issued what's called a Notice of Disallowance, ND number 12001GF1011. They concluded these benefits violated the rule against double compensation. They specifically cited Section 8, Article IXB of the 1987 Constitution. And they also pointed to a prior Supreme Court ruling, Civil Liberties Union v. Executive Secretary. COA's argument was pretty straightforward. These officials were already getting salaries from the BST. Since they held the PICCI positions ex officio, meaning because of their BSP roles, any additional benefits from PICI, regardless of what they were called, were seen as prohibited double compensation.
So basically, getting paid twice for what COA saw as fundamentally the same public service function?
That was their perspective, yes. The Notice of Disallowance directed the petitioners and also those who approved the payments to return the amounts.
Now, this is where the legal chess match really gets going. The petitioners didn't just roll over, they had their own precedent, right? The Sing Sing case.
That's right. They vigorously argued these benefits were not double compensation. Their defense rested on several points. They cited the monetary board resolutions authorizing the payments, PICCI's own bylaws, Section 30 of the Corporation Code, and crucially, this Sing Sing et al. V. COA case. They claimed Sing Sing specifically allowed RATA for ex officio members, and they argued their functions at PICCI were distinct enough from their BSP roles to make the Civil Liberties Union ruling inapplicable here.
So they were essentially saying, look, this is separate work for a separate entity, and the Supreme Court itself in Sing Sing said these kinds of allowances are okay.
Precisely. That was the core of their argument on appeal.
So how did the COA corporate government sector, the COA CGS, respond to that appeal, especially with the petitioners waiving the Singson precedent?
Well, the COA-CGS denied their appeal. They really held firm to their original position. They maintained that because the petitioners were ex officio members, the rule against additional compensation as laid out in Civil Liberties Union still applied. Full stop. They said, yes, PD 520 designated them ex officio, but it didn't specifically authorize additional pay. That authorization, they stressed, has to come from a specific law, not just PICCI's bylaws or internal resolutions.
Okay, so a general designation isn't enough. The law has to explicitly say you can get paid extra for this.
That was COA-CGS's stance. And while they acknowledged Singson allowed some RATA, they pointed out that even Singson stressed it shouldn't be indirect compensation. And importantly, it must be supported by evidence of actual use proof that the RATA was actually spent on representation or transport. COA-CGS even concluded the petitioners weren't acting in good faith when they received the amount.
Wait, not in good faith? That sounds like a pretty strong statement from COA. What did that mean practically, and why did they reach that conclusion?
It is a strong finding. COA likely reached that conclusion because they saw the petitioners accepting these increasing allowances, despite what COA believed was a clear constitutional ban and no specific law allowing it. For COA, acting in good faith generally means you genuinely believed you had a legal right to receive the payment. Their findings suggested the opposite here.
And that finding would make it harder to argue against returning the money, right?
Exactly. It weakens the argument that they shouldn't have to return funds received under a mistaken belief of legality.
Okay, so the petitioners strike out at COA-CGS. They then take it up to the COA proper, the main body. What was their final decision before this landed at the Supreme Court?
The COA proper, in its decision number 2017-020, dated February 16, 2017, actually partially granted the petition, so a slight shift. They allowed the P1000 per diem, specifically citing the Singson case as justification for that base amount. However, and this is the big part, they affirmed the disallowance of the excess per diems. That was P358,000. And they also affirmed the disallowance of the entire RATA and the other bonuses, which amounted to another P224,500.
So some relief on the basic per diem, but the increases and all the RATA and bonuses were still disallowed. A mixed bag, but mostly a loss for the petitioners at that stage.
Very much so. A significant portion of the disallowed amount remained. Their motion for reconsideration was then denied, which, set the stage for the appeal to the Supreme Court.
Okay, so with all that complex background, the case finally lands at the Supreme Court. They had several critical legal knots to untangle. What were the big questions they had to answer?
The Supreme Court essentially tackled four main issues. First, the basics. Is PICCI really a government-owned or controlled corporation, a GOCC? And is it therefore subject to COA's audit jurisdiction?
Right, got to establish that first.
Second, the core issue. Were the benefits the petitioners received unauthorized? Did they constitute double compensation under the Constitution?
The heart of the matter.
Third, were the subsequent increases in per diems and RA validly authorized? Or should those be disallowed? This involved looking at specific government orders, like Memorandum Order Number 20 and Executive Order Number 24, and also whether some new documents were admissible.
Okay.
And finally, number 4, are the petitioners solidarily liable for returning the amounts? Meaning, are they all equally on the hook for the disallowed funds?
All right, let's get into the rulings. First, that foundational question. PICCI's status as a GOCC. What did the SC say?
The Supreme Court firmly affirmed that PICCI is indeed a GOCC, no question about it. It was incorporated under PD 520. BSP was the sole stockholder. That satisfies the criteria. Organized as a corporation, vested with public functions, and majority owned by the government. The court actually reiterated its finding from the Singson case itself that PICCI is a subsidiary GOCC of BSP. So, unequivocally, COA had the right, the jurisdiction, to audit its finances. That part was clear.
Okay, check that box. Now, the core debate. Double compensation. Per diems and RATA versus those other bonuses. This distinction feels really critical. How did the SE justify saying per diems and RATA were okay, but not the bonuses? That seems like a fine line.
It is a fine line, and this is where the court made some crucial distinctions, drawing heavily on precedent. The court ruled that granting per diems and RATA to these BSP officials, concurrently holding ex officio positions in PICCI, does not violate the constitutional ban on double compensation.
Okay, so they agreed with the petitioners on that part.
Yes, on the principle for per diems and RATA. They explicitly applied their own precedent from the Singson case, which, remember, had already stated that a P1000 per diem and P1500 RATA did not violate the rule. The court found COA was actually being contradictory by disallowing the RATA when Sing Sing, plus various monetary board resolutions and even the corporation code, provided valid authority for it.
So the authority was there, legally speaking.
Right, and they emphasized that RATA is distinct from salary.
Right.
It's meant to defray expenses, representation, transport. It's more like a reimbursement.
Ah, so that's the key, whether it's for actual expenses incurred versus just extra pay.
That's precisely the distinction the court relies on. Diems are for attending meetings. RATA is for expenses related to performing official duties. The court views these as reimbursements or allowances for specific purposes, not direct compensation for services rendered.
Okay, that makes sense. But what about the other bonuses?
Well, on that point, the court agreed with COA. Those other bonuses were unauthorized. A bonus, the court reasoned, is a form of compensation for services rendered. It acts like additional salary. Therefore, it falls squarely under the double compensation problem the Constitution seeks to prevent, especially since there was no specific law authorizing the payment of those particular bonuses.
Got it. So per diems and RATA for expenses, okay if authorized. Bonuses treated as salary, not okay without a specific law.
You've got it. That's the essence of the distinction.
Now, what about the subsequent increases in the per diems and RATA? Were those deemed valid, or did they fall into that excess category that COA disallowed?
The Supreme Court ruled that those increases were also valid. They clarified the interpretation of Memorandum Order No. 20. MO 20 aimed to standardize benefits and suspended increases for GOCC executives, yes, but the court said it should only prohibit increases in excess of what comparable positions get in the national government. COA, the court said, erred by issuing a blanket disallowance without first determining if these specific increases actually exceeded those national government benchmarks.
So COA needed to do a comparison first.
Exactly. The court stressed MO 20 is about rationalizing pay, making it fair across the board, not about automatically disallowing any increase or discriminating against certain officials. Furthermore, they looked at Executive Order No. 24, which requires presidential approval for per diem increases. The court said EO 24 simply does not apply here.
Why not?
Because it took effect on March 21, 2011. The benefits in question here were granted before that, from January 2010 to February 2011. The principle of prospective application of laws, meaning laws generally apply forward, not backward, unless stated otherwise, was key. You can't apply a 2011 rule to actions taken in 2010.
Right. Basic legal principle. Makes sense. What about the new evidence the petitioners submitted during the process? Was that allowed? Sometimes courts are strict about that.
Yes, the Supreme Court confirmed the admissibility of those documents, things like the SEC certificate on PICCI's amended bylaws and additional monetary board resolutions. They reiterated that technical rules of procedure don't apply strictly in administrative cases like this. The goal is fairness and getting to the truth. Parties should have ample opportunity to present their case, especially when, the documents were submitted specifically to address COA's negative findings. Plus, COA itself didn't object to their admission at the time.
So the court prioritized substance over strict procedure there.
Correct. It highlights the court's focus on reaching a just decision based on all the relevant facts.
Okay, so putting it all together, what was the final word from the Supreme Court on the liability? Who had to pay back what in the end?
The Supreme Court granted the petition for certiorari filed by Tetangco and the others. This means it effectively nullified the COA decision from February 2017 and the resolution from September 2018, except, and this is important for the part where COA explicitly recognized the petitioner's entitlement to the base per diems. So the P1000 per diem was always considered valid.
So by granting the petition and nullifying the disallowance of the excess per diems and the RAA, the liability for those amounts was lifted.
Exactly. It implicitly lifted their liability for those specific amounts. The only thing they remain liable for, based on the ruling, would be those other bonuses, which the court agreed were unauthorized double compensation.
Fascinating outcome. This case really lays out some critical legal doctrines, doesn't it? Maybe we should recap those for our listeners.
Definitely. There are several key takeaways here that are important for understanding public service rules. First, the government-owned or controlled corporation, GOCC definition. A corporation is a GOCC if it's organized as a corporation, serves public needs, and is majority owned by the government, directly or indirectly. The ICCCI fits this, being a subsidiary of BSP, another GOCC.
And tied right into that is the COA's audit jurisdiction. The SC reinforced that COA can audit all GOCCs, whether they have original charters or were set up under regular corporate law. Broad accountability there.
Absolutely. Then there's the big one, the rule against double compensation from Article IXB, Section 8 of the Constitution. Public officers generally can't get additional pay unless a specific law authorizes it, but this case shows the nuance. Per diems for attendance and RATA for expenses can be allowed if authorized because they're seen differently from bonuses, which are treated like salary and need that explicit legal backing.
That distinction is crucial. And another key principle was the prospective application of laws, Article 4 Civil Code. Laws apply forward, not backward. That was vital for deciding EO 24 didn't apply to past actions.
Very important. And finally, two related points. The liberal admissibility of evidence in administrative cases, meaning technical rules are relaxed for fairness, and the underlying principle of standardization of compensation in government, aiming for equal pay for substantially equal work. MO20, trying to harmonize pay, shouldn't block increases unless they actually exceed national government standards for similar roles.
So quite a few layers unpacked there. What really stands out to you from this whole deep dive into Tetangco v. COA? It feels like the court was really trying to balance different principles.
I think what stands out is how even clear constitutional principles, like the ban on double compensation, require careful application in specific complex situations. Especially with these ex officio roles and different types of allowances, it really underscores how vital precise legal authority is for any extra payments in public service. It provides clarity but still allows for legitimate, necessary expenses to be covered. It's a nuanced balance.
It really is. This whole deep dive makes me wonder, though, looking forward, how might policies evolve? How do you balance needing to attract top talent for multiple demanding public service roles with, the absolute need for fiscal responsibility and avoiding even the appearance of double dipping? That seems like a constant challenge. What are your thoughts on that? We genuinely love to hear your comments on this. And please, if you found this deep dive enlightening, feel free to favorite it. For more insights like these, making sure you're always well informed on the critical issues shaping our society, please be sure to subscribe to The Deep Dive wherever you get your audio content. Don't miss out on another in-depth exploration of key cases and sources. Subscribe now and join our community of curious learners.